not the first. My lords, may
Where
kindly
is
see
it
the
stated
contentions.
where is it stated in the
Yes, my lords, my kind
FIR?
lords.
FIR.
Yes, page 14, my lords, please. A tripartite agreement was signed on 25/10/2022 between Formula E Operations, a company registered under the laws of United. My lord, pausing here, my lord, I'll just bring the arbitration which is now said was withdrawn by this company itself. My lord, I'll place those papers before. Your lordship may kindly record it, my lord, that arbitration was withdrawn by this company itself.
When it was withdrawn?
My lord, I'll give the date. It was withdrawn
after the payments made or before the payment?
No, my lord. After the payment, they took all the monies and then cancelled.
Okay.
My lord, a company registered under the laws for conducting Formula E races for seasons number so and so. Under this agreement, the role of the government was limited to the extent of building the track for the event and providing other civic amenities. The event was conducted on 11/2. The HMDA has incurred an expenditure of 12 crore for the event. The fee and other payments were paid to the sponsor. Notes may kindly see. None of the amounts were received by the government. My lord, so much is said that there was a profit. If there was a profit, my lord, this
no, fees and other payments were paid by the sponsor,
not in every case.
They were paid by the sponsor.
My lord, if there was a profit, my lord, the sponsor would not have gone, my lord. That's not an issue before your lordship now, my lord. That whether there was a profit or no profit. And only saying, my lord, that the second one, my lord, while the tripartite agreement dated 25/10/2022 was in force, differences seem to have cropped between FEO and the sponsor, resulting in the latter backing out from the conduct of the racing events for season 10. As per the above agreement, part fee payment was overdue by May 2023. Subsequently, discussions were held between the senior officials of MAUD, HMDA and FEO, representatives about the possibility of the state government taking up the role of the private sponsor and paying the fee. Private sponsor, you are coming into the place of a private sponsor. The special CS holding full additional charge of Metropolitan Commissioner HMDA had put the HMDA file to the then Minister MAUD, who is a petitioner now before your lordship, seeking approval for the following. Long form agreement executed for seasons 9 was signed by Special CS MAUD, Department of Telangana on behalf of MAUD. The present draft mentions HMDA as a promoter and host instead of ACE Next Generation Private Limited. This was the sponsor earlier. And MAUD department respectively. As such, due authorization in favor of MC HMDA is required for undertaking the responsibility of promoter and host city. Administrative approval sanctions in respect of the payment of fee and tax, 90,000 British pounds plus applicable taxes, which when converted to approximately 110 crore. There seems to be some mistake. There seems to be that they think that it's a profit. That's the expenditure. And approximately 50 crores for undertaking other ancillary works for conducting the event, including but not limited to civil works and municipal services, the amount totaling to 160 crores. That would be the expenditure which could have incurred. For making payment of fee of 22 lakhs 50,000 towards first installment, as per the draft LFA, the then Minister for MAUD had duly approved the same on the file of HMDA. When the matter stood thus, HMDA received an invoice for so and so dated 22 lakhs 50,000. That would be 22 crores and so, plus applicable taxes and commission towards first installment of season 10. Promoter's fee, HMDA received another invoice for dated so and so, plus applicable, that's for an amount of rupees 23 crores, plus applicable taxes and commission towards the second installment of season. On 3/10/2023, a proceeding was issued by the Chief Engineer HMDA sanctioning 22 crores, 22 lakhs 50,000 of pounds towards first installment of the season. On 11/10/2023, another proceeding was issued by the Chief Engineer HMDA sanctioning 22 lakhs 50,000 towards the second installment of the season. Accordingly, the amounts were transferred to FEO through Indian Overseas Bank on the same day. These amounts were paid on 11/10. Agreement was entered into on 30/10. Your Lordship knows the first agreement was with the this, what is this next, AS Gen Next. That agreement, your lordship will please to see there, the first agreement will have the name of AS Gen Next. First agreement, my lord. AS Gen Next. The agreement dated, I don't know what is the 22/10/2022.
1 second.
25/10/2022.
Where do we get date on the internal page? 10. Yes, this is 25th October.
Well, this is in between. Well, your lordship will find AS Gen Next Private Limited.
Let us examine what is the scope of the parties, obligations of the parties.
Well, that sponsorer was supposed to do the whole of the job. That is what is given.
I understand. In a nutshell, to know whether, in case if the sponsorer backs out, is there any?
Well, you had to proceed against the AS Gen Next for defaulting, because this agreement is also for a period of 3 years. For there no procedure.
That aspect. See, we'll go into that aspect. But basically, in case if the sponsorer backs out, is there any clause in the agreements, either this agreement or the supplementary agreement, enabling or entitling the government to pay?
The obligation to pay on the government is there, not in the first one, only in the second one. In the first agreement, my lord, which is now cancelled.
Let's see the payment obligations.
My lord, I don't have a copy of that, my lord. My friend has got only one.
Yes,
this is a lunch motion which is moved. There can't be an urgency in a matter of this nature. There is no urgency in a matter of this nature. My lord, if it's a bail or anything, your lordships can always understand. My lord, it's moved by way of a lunch motion. My lord, a quash petition. Your lordships may kindly. I'm only reading from your own agreement, my lord. I'm not reading from anything else. Not even a single scrap of paper I filed before your lordship, nor am I showing it to you. My lord, I will show everything, my lord. Your lordships may kindly have it on any other day. In the event, my lord, your lordships think that this my lord, petition has to be entertained. My lord, your lordships have to first take a decision, my lord, whether this petition can be entertained or not. At this stage,
no, unless the obligations of the parties are examined, because the entire issue arises out of two agreements. That is the genesis of the.
My lord, the obligation is on the state. My lord, it is not denied either by the senior counsel or anybody that the obligations will not fall on the state.
What is the case made out on the petitioner?
No, the case made out. My lord, I'll bring that to your lordship's notice. Para 12, your lordship will please. My lord, I'll only. My lord, these amounts, my lord, your lordships have seen 6 amounts were paid for the purpose of the second contract, even before the contract was entered into.
Page 14, this is only the role of the accused number 1. He signed and approved the file on 27/9/2023. After that, no role at all. And he approved the payment to be made by the HMD, agreement to be entered by. After payment, everything is processed by the department. It is their responsibility with the violation of the procedures. After that, there is nothing about.
My lord, I'll have to show to your lordships. My lord, 6 your lordships have seen. There is no denial of the fact that these 2 amounts were paid before the agreement dated 30/10/2023 was entered into us.
Para 6, page 15.
Para 15. These amounts, my lord, were paid even before the agreement was entered into. In both the instances, even though foreign remittances were made, no formal approvals of the relevant regulatory authorities were obtained before transferring huge amounts. My lord, apart from huge amounts, they were, my lord, foreign remittances. Remittances resulted in additional tax burden to the HMDA, which has made to pay 8 crores to the income tax department towards withholding tax for 2 installments. The HMDA released a sum of rupees 1 crore 10 lakhs to the Federation of Motor Sports Club of India towards FIA inscription, interstate championship calendar and permit fee. The total amount thus paid by HMDA is 54 crores. All these payments were made from the general funds of HMDA. As per the established procedure in HMDA administrative sanction of works expenditure, amounts exceeding 10 crores should be obtained from the government. The government accords such sanction in concurrence with the finance department. In this case, it is noticed that this procedure was not followed. But these are all issues for investigation. By reference dated above 7/10/2023, an email communication was received from so and so for which it was terminated. The agreement dated 25/10/2022 by the reference first above. However, the consent of the parties to the agreement was not taken by FEO before terminating the above agreement. It's further noticed that the above payments were made even though there was no obligation to make these payments under the then subsisting agreement. Apparently, these payments were made in anticipation of an agreement. My lords will please see that. In anticipation of an agreement that was supposed to be executed. This is a grave irregularity. The second line in that page 16 also, it is further noticed that the above payments were made even though there was no obligation to make these payments under the then subsisting agreement. It is not paid under the earlier agreement. It is paid for the agreement which is not yet entered into and which was entered into on 30/10. Apparently, these payments were made in anticipation of an agreement that was supposed to be executed in a grave irregularity. This would amount to 409 straight away. After making the above payments, Lordship will please take 10. After making the above payments, a new agreement dated 3/10/2023 dated 3rd was signed between FEO and MAUD. Under this new agreement, the government took the responsibility of not only paying the sponsor fee of 90 crores, but also the burden of providing civic and logistic support in the form of laying the track in the event. Then the model code of conduct. 12, your lordship will please to see. The HMDA in the reference 7th above, while enclosing the relevant record, has informed the government that HMDA have noticed the following grave lapses, irregularities in the matter. The total payment of 54 crores was paid to FEO and others in gross violation of the established procedure. The approval of the competent authority in concurrence with finance department was not obtained. My lord, if everybody was allowed to make the payments in the manner in which, my lord, there is a system under which you function. Otherwise, my lord, there would not be left anything. A total payment of 54 crores, I'm sorry, though HMDA was not a party to the agreement, HMDA made the payments. HMDA made the payments because, my lord, the petitioner before lordships authorized that payment.
Government was a party.
There can't be any continuation. The payments were made before the agreement dated. See, my lord, the payments were made even before the agreement dated 30/10/2023 was signed between the parties. A part payment was made when the MCC was in force without taking any approval from ECI. That's not. Payments were made in foreign currency in violation of the existing rules and regulations related to foreign exchange remittances. Report sent by HMDA along with the available record has been examined thoroughly in the government. 70. My lord, I'll bring that only one business rules for your lordship's consideration that the.
So please make submissions on 13(1)(a) and 13(2). What is the?
I'll bring that to your lordship.
What is the direct benefit the petitioner has derived from entire?
My lord, that would be part of the investigation. My lord, you don't say.
No, there is no clear finding to that.
My lord, what we would like to bring to your lordship's notice now is the irregularity which is committed. As to who received what amount would be subject to the investigation. Investigation, your lordship, at this stage, we cannot say that you have received so much or they have received so much or who has received what.
The FIR then.
It can be only part of the investigation. This
No,
is
the
not
FIR can't be that investigation will find out whether there has been an offence. FIR must prima facie disclose an offence.
more
Sir,
than
let the.
I'm sorry. Yes.
more than prima facie is there before your lordships here. More than prima facie. My lord, what I would like to bring to your lordship's notice, the remaining part, my lord, as to, my lord, how much is benefited by each, what is misappropriated, how much is misappropriated, what is the loss to the state, how much is benefited by anybody, would be a subject matter of investigation, not now, my lord. I would only bring to your lordship's notice the irregularities which were committed. And that is now sought to be quashed. My lord, 15 also, your lordship will please to see. By the reference 6 above, the government on 26/10/2023 submitted a reply to the breach of agreement notice issued to FEO, wherein the government have asserted that the notice of breach of agreement has no legal validity as the agreement is not in accordance with law and involves huge loss to the state. It was also informed that the agreement was conducted without necessary authorization and competence by the individuals involved. The government have informed that the agreement is a fraud perpetrated on the government of Telangana by the parties to the agreement. 16. As per the above agreement, there is a financial commitment of 600 crores. My lord, your lordship will please to see 16. Along with additional recurring expenditure for next 3 years. However, no administrative approval from the competent authority, including clearance from the finance department, was obtained by the officer concerned before entering into the agreement dated 30/10/2023 by and between FEO and the government. The agreement dated 30/10/2023 was executed when the Model Code of Conduct was in force without approval of the Election Commission of India. Because, my lord, 30/10/2023, my lord, the amounts were paid, or 30/10/2020. I'm not on that, my lord. Payment of monies before the agreement is executed, my lord, is a serious flaw. Second, my lord, that money and as well as the agreement were entered into during the Model Code of Conduct. Not much, my lord. It is one of the issue which is brought before your lordships. But the monies were paid, my lord, much before the agreement, my lord, which could throw, my lord, it's absolutely improper, and my lord, anything during the course of an investigation, anything would come before your lordships. All issues would come before your lordships after investigation, not at this stage. Here, my lord, we are only, my lord, on the basis of a preliminary inquiry. This is said on the basis of a preliminary inquiry. Satisfaction is recorded, my lord, by the Excellency the Governor, and a permission is granted. Now, my lord, what is there before your lordships is an affair which could be subject to investigation, and my lord, subject to, my lord, so many issues which might come up before your lordships. Number of accused may, my lord, increase. Amounts will be there during the course of investigation. All of them would be part of the charge sheet. Not for the purpose of, my lord, bringing all those things to your lordship's notice at this stage. There is no, my friend is saying business rules, my lord. There is no denial of the fact that it has to be taken by my lord, that's a different issue. You have to take this, my lord. That's our case before lords.
Yes.
My lord, in these circumstances, my lord, interference at this stage, my lord, I have shown to your lordship that there was a preliminary inquiry. I showed to your lordships there is, my lord, a preliminary stage of investigation which is being taken place into irregularities or serious irregularities of an amount of rupees more than 56 crores paid, my lord, pursuant to an agreement, my lord, which pursuant to an agreement, my lord, which was entered later. Money was paid earlier. Now, these are all issues, my lord, which could form part of the investigation. Now, my lord, what is cited before your lordships are the judgment of Lalita Kumari and all. My lord, Lalita Kumari, much is said about investigation, preliminary investigation. Showed to your lordship, preliminary investigation was done. My lord, in so far as, my lord, Charan Singh is the same thing, my lord, regarding preliminary investigation. These two, my lord, I've satisfied your lordship that there is enough material, even at this stage, in the first information report itself, that a preliminary inquiry was done. My lord, in the case of, my lord, at page 120, a judgment is shown to your lordships. And, my lord, much is read out of those judgments, my lord, page 120, my lord. 144 was read to your lordships. My lord, these judgment cannot be made applicable at this stage. My lords may kindly take note of the fact that these judgment cannot be taken at this stage, because this is after a trial. After a trial, after a conviction, after the matter went to the Supreme Court. This is not at the stage of FIR, my lord. These principles cannot be made applicable now. What would come out in the investigation, my lord, is an issue to be seen. You cannot bring judgments, my lord, in respect of which, my lord, matters have been settled, evidence has been laid, charge sheets have been filed, evidence has been laid. My lord, those principles cannot be brought, my lord, for the purpose of, my lord, asking a quashing to be entertained by your lordships. My lords, your lordships have repeatedly held, my lord, quashings, my lord, at this stage would not be entertainable. Quashings, my lord, at a stage, my lord, at the stage of FIR would not be entertainable. My lord, I'll just set one judgment, my lord. 2009-11 SCC 737. My lords may kindly take 746 for once, my lord. 2009-11 SCC 737 it starts. My lords may kindly take 746, my lord.
Yes.
ఇవ్వండి కాపీ ఉంటే ఇవ్వండి వాళ్ళ తిరిగి మనం చేస్తే వాళ్ళు చేసినట్టు మేము చేస్తే సార్ వాళ్ళు మా టీచర్లు అవుతారు బ్యాక్గ్రౌండ్ స్పాక్స్ my lords. While accused, my lords have got it. While accused K.
Yes.
K. Margabantu at the relevant time was the chairman and managing director of United Commercial Banks. So and so, my lord, all these are accused. Suresh was the assistant manager, National Housing Bank. He used to report to accuse Sri so and so in regard to his function and worked under his instructions. My lords, may kindly go to page 145. My lord, para 145, my lord, I'm sorry. Only to show to your lordships regarding this entrustment thing, my lord. Fortunately, my lord, it is agreed, my lord, that the petitioner, my lord, is in charge. He is a minister, my lord, he is in charge. There is no two ways about it. There can't be any specific entrustment. The fact that one is a minister, the entrustment of the public is there with him. 145, my lord.
Yes.
In so and so Desai was the state of Bombay, this court observed to establish a charge of criminal breach of trust. The prosecution is not obliged to prove and the precise mode of conversion, misappropriation or misapplication by the accused of the property entrusted to him or which he has dominion. The principal ingredient of the offence being dishonest misappropriation or conversion, which may not ordinarily be a matter of direct proof, entrustment of property and failure in breach of an obligation to account for the property entrusted, if proved, may be in the light of other circumstances justifiably lead to an inference of dishonest misappropriation or conversion. Conviction of a person, my lord, pausing here, I'll bring to your lordship's notice. I'm only bringing these to your lordship's notice. These are all which could come out during the course of investigation. It could come out during the course of investigation, not now. Because much is said that everything should be found here in the FIR. My lord, I'm citing this judgment for your lordships. Offence of criminal breach of trust may not in all cases be founded merely on his failure to account for the property entrusted to him or which he has dominion, even when a duty to account is imposed upon him, but where he is unable to account or renders an explanation for his failure to account, which is untrue, an inference of misappropriation with dishonest intent may readily be made. My lord, however, section 407 makes special provisions for various cases in which property is entrusted to the enumerated categories of persons who commit the offence. Criminal breach of trust by a public servant is dealt in 409 after the section. This section classes together public servants, my lord, bankers and all others. The duties of such persons are of a highly confidential character involving great powers of control over the property entrusted to them, and a breach of trust by such persons may often induce serious public and private calamity. High morality is expected of these persons. They are to discharge their duties honestly. The following are the ingredients of the offence under this section. Accused must be a public servant. The petitioner being a public servant is not in dispute. The petitioner having signed, my lord, the files by which, my lord, amounts were paid to a tune of 56 crores in respect of an agreement which was sought to be entered into and before it was entered into, are enough material to show to your lordship that these are matters which are to be subjected to investigation and not to be, my lord, adjudicated at this stage.
Yes.
My lord, these citations, my lord, I'm only bringing to your lordship's notice that These are issues which will come out during the course of investigation. My lord, 2021, my lord, 2021, 19 SCC 401, only 1 or 2 paragraphs, my lord, only to show to your lordship that what are the, my lord, what is the scope of inquiry now, my lord, before this honorable court under 482 to quash an FIR. I will be only able to show to your lordship that there was a preliminary inquiry and, my lord, there was serious irregularities which took place. My lord, para 21, your lordship will please. 21, my lord. The aforesaid is required to be considered from another angle also. Granting of such blanket order would not only adverse affect the investigation but would have far-reaching implications for maintaining the rule of law. Where the investigation is stayed for a long time, even if the stay is ultimately vacated, the subsequent investigation may not be very fruitful for the simple reason that the evidence may no longer be available. Therefore, in case the accused named in the FIR complaint apprehends his arrest, he has a remedy to apply for anticipatory bail under section 438, and on the conditions of grant of anticipatory bail under section 438 being satisfied, he may be released on anticipatory bail by the competent court. Therefore, it cannot be said that the accused is remediless. It cannot be disputed that the anticipatory bail under section 438 can be granted on the conditions prescribed under 438 was satisfied. At the same time, it is to be noted that arrest is not a must whenever an FIR, if a cognizable offence is lodged. Still, in case a person is apprehending his arrest, his connection with the FIR disclosing cognizable offence, as observed here and above, he has a remedy to apply for anticipatory bail under not under 438. Not a quashing, my lord. This is off-quoted, my lord. I'm only just bringing to your lordship's notice, no, not that, my lord, these are not known to the court, my lord, only to make my point, my lord, that these are not matters, my lord, which cannot be investigated at this stage. It's at the stage of FIR. You want me to look at it like an encyclopedia, having everything into it. That could be only after investigation. Prima facie, two things I have to satisfy your lordships, that there is a serious irregularity. Serious irregularity for sure, because amounts were paid in respect of an agreement which was not entered into at all. Amounts were paid, my lord, without following the procedure established. 56 crores of amount were paid without taking the concurrence of any of the, my lord, the government as established, my lord, under the business rules, and, my lord, as the procedure there, my lord. Nobody can handle the monies of the state, my lord, in the manner in which you please. My lord, these are things which I would like to establish before. All other things, my lord, will come out in the investigation. At this stage, my lord, there cannot be any entire, my lord, evidence be placed before your lordship. During the course of investigation, my lord, what would come to the fore, my lord, would be placed before your lordships. It's not a case, my lord, where it can be entertained at all, my lord, the 482 petition. Leave alone, my lord, any sort of an interim order.
Please. My lord, may I just take
One
5
other
minutes?
judgment, my lord, it's an off-quoted judgment, my lord, one judgment, my lord. This is the most...
One minute.
Para 24, my lords, also will please to see. That's the judgment which I am supposed to pass to your lords. 24, my lord. Para 24, your lordship will please to see, my lord, in the judgment, earlier the judgment, my lord. Para 24, that is what is extracted over here. My lord, para 13 onwards, my lords will please to see for once. There can be no dispute over the proposition that inherent power in matters of quashment of FIR has to be exercised sparingly and with caution. And when and only when the such exercise is justified by the test of specifically laid down in the provision itself, there is no denial of the fact that the power under 482 is very wide, but it needs no special emphasis to state that the conferment of wide powers requires the court to be more cautious. It casts an onerous and more diligent duty on the court. My lord, so and so judgment, my lord, 15, your lordship. We have referred to the said decisions only to stress upon the issue how the exercise of jurisdiction of the High Court in a proceeding relating to quashment of FIR can be justified. We repeat, even at the cost of repetition, that the said power has to be exercised in a very sparing manner, and it is not to be used to choke or smother the prosecution that is legitimate. The surprise that was expressed almost 4 decades ago in Kurukshetra University case compels us to observe that we are also surprised by the impugned order. It was quashed, the Supreme Court set it aside. In the instant case, the High Court has not referred to allegations made in the FIR or that what has come out in the investigation. It has noted that correctly that the investigation is in progress and it is not appropriate to stay the investigation at these cases. It was disposed of on the application that 482 that while doing that it was directed that the investigation agency shall not arrest the accused person. This direction amounts to an order under 438 Criminal Procedure Code, albeit without satisfaction of the conditions of the said provision. This is legally unacceptable. But there cannot be any interim order in this case. If they so apprehend, there can always be a 438, 439, whatever it is. There cannot be an interim order in a 482(1). In a case we have said, where there is preliminary inquiry, I was able to show to your lordships the nature of preliminary inquiry done, the permission obtained from the governor, all these were taken place, and a preliminary nature of investigation, the misappropriation, or misconduct, irregularity of a serious nature, I was able to bring to your lordship's notice. The glaring thing is, money is being paid before the agreement is entered. Now, there cannot be an interim order of any nature in this matter, my case before lordships is, that petition itself cannot be entertained at all.
If I can take just 5 minutes of your lordship's time.
If your lordships were to come to a conclusion that we are supposed to file our counter and file material, we will file all those material. But there cannot be any interim order of this nature. As the Supreme Court said, it's always open to file any petition.
If I can take just 5 minutes in rejoinder. There are 3 basic errors in the Learned Advocate General's submissions, and I'll state straight away what they are. When Lalita Kumari and Charan Singh talk about a preliminary inquiry, they talk about a preliminary inquiry by the investigating police officer. The inquiry is when the complainant gives the complaint, the first information to the police officer concerned. Before that police officer registers the FIR, he has to conduct a preliminary inquiry. Learned Advocate General is going on the basis that the complainant, which is the government, had an inquiry before they filed the complaint. That is not Lalita Kumari's case, that the complainant must have an inquiry before they file the case. Lalita Kumari and Charan Singh say that when an FIR is received, here the FIR is received from the government only on 18th December. The officer receiving the FIR has to conduct a preliminary inquiry. What the Learned Advocate General is saying is that the government, before they filed the complaint, had an inquiry. That is nothing to do with the ratio of Lalita Kumari and Charan Singh. It's like saying the complainant made a preliminary inquiry before he filed the FIR. Therefore, no inquiry is required thereafter. It goes totally against the judgment. But the question is, after the FIR was received, was there an inquiry before registering it? Not whether the government, before they filed the FIR, inquired within themselves whether they should file the FIR. That is not the inquiry there. That is point number 1. It's a basic error, my lords, in the law, stated by my learned colleague.
Page 20 last, my lord, it was given on 1810. Lordship, page 20 last. My lord.
1810 to the government.
Enclosure 2.
Okay, my lord, can I just repeat what I'm saying? 1810 was the complaint that the government gave for the purpose of getting sanction. The FIR after sanction is presented to the police officer on the 18th of December. Please, my lord, see page 12. We can't look beyond the document. FIR.
There is no doubt about it.
18th.
Yes, yes.
That's it. My learned friend is saying 18th October. 18th October is when the government decided that they wanted to file a complaint and went for the governor's sanction. That is not the inquiry in Lalita Kumari. Lalita Kumari doesn't say that the inquiry conducted by the complainant before he lodges the complaint is the inquiry to be conducted.
My lord, we are
The
coming back
inquiry to be
my lord.
conducted
Page
is
12,
by
page
the
12,
officer
serial number 3, my lord.
to
Page
whom
12,
the FIR is presented. The
occurrence of offence, page 3, my lord. Serial number 3,
I
at page
just
12.
Yes.
This is, my lord, I only showed the enclosure 3, occurrence of offence prior to 18/10/2024.
yes, I agree with you. In fact, the occurrence, according to you, took place on 30th October 2023. That is according to you. The offence was on 30th October 23. But the point is, Lalita Kumari and Charan Singh say, when the officer who is to register the FIR receives an information report, before he registers that information report, he has to conduct a preliminary inquiry. That is the judgment. Not that the complainant has to conduct an inquiry before they file an FIR. The learned advocate general is going on the basis that the complainant conducted an inquiry before filing the FIR. That is not the inquiry contemplated in either Lalita Kumari or Charan Singh. The inquiry is that when the investigative officer received the FIR on 18th December at 5:30, that inquiring or that investigative officer, did he conduct an inquiry before 19th December to register the FIR? That is the test. Not that the government conducted an internal inquiry, they conducted an internal inquiry, then they went for sanction. They are the complainant here. The government is not the investigative officer. So their inquiry is the inquiry by the complainant. In which cases, Lalita Kumari and Charan Singh become totally ocious. They're not worth the paper they're written on. We run a coach and four through them. So, my lords, my learned friend referring to how the government conducted internal inquiries of no relevance. Question is, did the investigative officer, when he received the first information report, when there was a delay of more than 3 months, when it was a matter of corruption, did he conduct a preliminary inquiry to see whether that complaint made out an offense? That is number one, the basic error. Number two, the basic error made by my learned friend, the learned advocate general, is this. Your lordship asked him a pointed question. Where does your FIR make out the ingredients of 13(1)(a)? His answer was, the investigation will disclose that. I'm sorry, my lord, but the law is very clear. If the FIR does not disclose in itself the ingredients of an offense, that is a ground for quashing. That is Bhajan Lal. In which case, let them conduct a further investigation. That is why we have a preliminary inquiry. That is why Lalita Kumari said there must be an inquiry before you register it. If they had had that inquiry as is contemplated, then what my learned friend is saying, we would have found material to make out the ingredients. I can understand. The two are connected. So my learned friend saying the purpose of investigation is to find the ingredients is wrong. A criminal case is not a fishing expedition. The ingredients are made out. Purpose of investigation is to garner the evidence. The purpose of investigation is not to find the ingredient. My lord, ground for quashing, first ground for quashing is the FIR does not disclose a offense. The averments in the FIR do not make out the ingredients of the offense. When that is shown to my lord quashes that FIR is quashed. Because that FIR does not. The answer of the learned Advocate General is, my FIR need not show the ingredients of the offense. My FIR shows I have a suspicion, so I want to investigate to find the ingredients of the offense. Well, that's a basic error. Well, it's a third basic error which my learned friend has made is about the issue of the stay of an arrest. Although I'm saying I want a complete stay, but your lordship's court, coordinate bench, this matter has already been decided at page 156. Page 156. The order starts at 154, 156. May I just read this, my lords? Counsel representing so-and-so would contend that the contents lack the ingredients. This was my argument, to which the learned Advocate General will say, my investigation will find the ingredients. You can't say, my FIR has no ingredients. So even Bhajanlal says then it must be quashed. But please don't quash it, because I'll investigate and then find the ingredients. Lack the ingredients of the offense alleged against the petitioner. There is no explanation for the delay caused in lodging. My learned friend, that's not fatal according to him. There is no whisper about the offences punishable in the complaint. Petitioner will cooperate. He would further submit that the petitioner is a sitting MLA. Due to political rivalry, second respondent implicated him. Without verifying the contents of the complaint and without conducting any inquiry, that is the point I'm also making, police registered the subject crime, which is in violation of principles laid down by the Honorable Apex Court. That is, my lords, Lalita Kumari and Charan Singh. Also the procedure. As discussed, Supra, there is no explanation for the delay caused in lodging the complaint. Prima facie contents of the complaint lack the very ingredients. And I repeat that, to which my learned friend's answer is, I will find out the ingredients in investigation. At this stage, the ingredients are not there. Lack the very ingredients of the offences alleged against the petitioner. In a matter like this, custodial investigation of petitioner is not required. He is a sitting MLA. Please note the next lines. This court is having power under section 482 of CRPC. My learned friend said it can't be done. It has to be done under 438. This court is having power under section 482 CRPC to grant protection to the accused as held, relying on another judgment of this honorable court, as held by this court with a order dated so-and-so in criminal MP so-and-so. Therefore, investigating officer pending on the file is directed not to attend to arrest the petitioner. My lords, I submit that when such contentious factual issues where the learned Advocate General agrees that investigation is necessary to make out the ingredients, himself does not show how the sections are made out, but says his investigation will get the material to show how the sections are made out. At this juncture, it's definitely a case, my lords, for my 482 to be entertained by your lordships. Let them file their counter. It's definitely a case for section 482 to be.
Yes, that's all.
It is my submission, therefore, that this is definitely a case. Let the state file a counter. Till then, your lordships will stay the proceedings or pass an order similar to what your lordships find at page 156 and give protection. And that is my submission to your lordships.
But there can't be any similar case, my lord. We have what the offences now before your lordships are different. The Prevention of Corruption Act and 409. Those are not the offences, my lord. In that
propositions of law are the same.
My lord, insofar as my case before lordships, that there cannot be an interim order, my lord. This would, my lord, that they should file a bail petition is not what I said, my lord. It's the Supreme Court which said you file a bail petition, not a 482. My lord, 482, my lord, basic, my lord, the allegations in the FIR would only show, my lord, that there was an irregularity which was committed, which is supposed to be investigated. Amount of 54 crores was paid, my lord, which is a loss to the state exchequer. My lord, those are supposed to be investigated.
My lords, my relief sought in the 482 is for stay of the further proceedings. The relief which your lordship saw at page 156 is a smaller relief than a relief of stay. If the larger relief of stay of the proceedings is passed, then the question does not arise. But what was done at page 156 was the larger relief of stay of investigation was not given, but a stay of the arrest was given. Because stay of investigation is a larger relief. When a court has the power to grant a larger relief, if your lordship stayed all further proceedings, which you have power under 482, when entertaining a quashing or against an FIR, your lordship has a power to stay all further proceedings pursuant to the FIR. That is a larger power, admittedly aware. Page 156, a smaller power has been exercised and not a larger power. And when a court, a superior court, has a power to grant a relief, it always has a power to grant a relief, to mold the relief at less than that stage. So my learned friend saying that power is not there is very strange.
Yes.
In a quashing.
In a quashing.
I understand, my lord, your lordship's court in a quashing, even after the bail, after the arrest, your lordships have granted interim bail. I'll explain why, my lord. If your lordship today stayed further proceedings, just said stay of further proceedings. That's my prayer, and that can always be granted. When your lordship admits the 482, you can stay further proceedings. If your lordship stays for the proceedings, automatically there is a stay of anything coercive. There is a stay of arrest. Because the proceedings are stayed, they cannot arrest. So automatically they cannot arrest because there is a stay of further proceedings. Now, that is why, my lord, very often your lordship will say apex court also when entertaining says no coercive steps to be taken, because that's a lesser relief. My relief I've asked for, which your lordship will see, page 11. 11 is the relief I have asked for, and I have asked for, it is therefore prayed that this honorable court may be pleased to call for the records relating to crime number so-and-so, quash the same. It is prayed that this honorable court may be pleased to stay all further proceedings, including the arrest. Because if the proceedings are stayed, if the FIR is stayed, there is no question of arrest. Because if you stay proceedings, arrest is one stage of the proceedings. So if there is a stay of the proceedings, ipso facto, there's no question of necessarily saying stay of arrest, because an arrest is one more stage in the proceedings, and all stages of the proceedings are stayed. At page 156, a lesser relief was granted by the court. That's why I started by saying I'm seeking the relief at page 11, my lords. And that my learned friend can't say, your lordship cannot pass. That's passed in all matters of 482.
Yes. State is taking notice for 1 and 2, or notice has to go to 2?
1 and 2. 1 and 2.
1 and 2. State takes notice for 1 and 2.
Lordship order notice to 2, my lord, since 2 has made
Notice
separate.
to 2, personal notice permitted. Then the petitioner herein is the accused number 1. in crime number 12 of RC0 RCO-CIU ACB-224 on the file of police station ACB CIU Hyderabad, which is registered under offences under section 13(1)A read with section 13(2) of Prevention of Corruption Act 1988, section 409 read with section 120B IPC. The petition is now filed to quash the proceedings in so and so. The in the FIR dated 19/12/2024, the the facts rising to file to lodge the FIR is that based on agreements, a tripartite agreements dated 25/10/2022 entered between Formula E Operations. Who are these parties? Formula E Operations and Municipal Administration and Urban Development Department, Hyderabad, Government of Telangana, and a third party, ACE Next Generation Private Limited, full stop, for conducting e-formula races for 9, 10, 11, and 12 in Hyderabad. The Shri, what's his name? Page, this page. Learned Senior Counsel C.A. Sundaresan submits that the FIR, basically the FIR has been uh, filed on that an information was received by ACB CIU office road number 12 Hyderabad on 18/12/2024 at 17:30 hours, and immediately an FIR has been lodged under section 173 BNSS dated 19/12/2024, and he would submit that the in view on that within a period of 1 day without making any preliminary inquiry and in view of political vendetta has directly filed has and without any whisper of pecuniary benefit being benefited to the petitioner has lodged the complaint on 19/12/2024, which is against without even making preliminary inquiry, and that the under sections and that the FIR has been and that the uh, offences read in as section comprising of in connection to the Prevention of Corruption Act 1988 and no ingredients have been made to the in the complaint which would attract the provisions of section 13(1)A read with 13(2) of Prevention of Corruption Act 1988 and section 409 read with 120B of 120-B of IPC. It appears that earlier there was an agreement between the parties on initial agreement was entered on 25/10/2022, first agreement, and later it was terminated on 27/2023, and later a second agreement was entered on 30/10/2023, and and that the and 30/10/2023, and the which and he would further submit that since the agreement has been terminated, and in order to keep up the in order keep up the obligations as per the terms of the agreement, the then government has to take up the event of continuing the event. In such a situation, in situations, amounts have been paid by the government much before uh, has been paid. Full stop. As such, there is no case made out against the petitioner for to be investigated under the said provisions. Full stop. In support of his case, learned senior counsel uh, refers to 2014 to SCC. I'll tell you all that. Per contra, learned Advocate General would submit that the papers, fresh papers, problem with that. The AG submissions. Hmm? Fresh papers పెట్టాలి కదా. You would submit that the in the while that the there was a serious flaw in making the payments which are making the payments, and that the petitioner has not during at the then point of time was a minister for MAUD full stop, and has not taken approvals, and there is a serious flaw in making the payments which is not in accordance to the which is not in accordance to the business rules and business rules, and that only a FIR has been launched, has been um, FIR has been made, which has a preliminary, which is prima facie proves that the petitioner has not followed it, has totally deviated the terms of conditions of the agreement, and also not followed the provisions as contemplated. Besides that, there is a sanction of His Excellency Governor so and so for registering the which is that enclosure you're referring to, the third
overlay.
Wherein a sanction was ID memo dated 17/12/2024, General Administration, conveying decision of the Honorable Governor Telangana in respect of the petitioner, full stop, and submits that that the petitioner has as such, unless a detailed inquiry is conducted, full stop, there cannot be any reason to quash this criminal petitions. Per contra, learned senior counsel would further reiterate that the inquiry which has been that there is no inquiry conducted by the investigating officer, and the complaint was made based on a preliminary inquiry made by the by the respondent, by the government, and it is the duty of the investigating officer to conduct inquiry, and after arriving to a conclusion that a prima facie case is made out, the FIR may be launched, maybe FIR may be filed, and that the FIR also does not satisfy the provisions of section 13 of PC so and so. So this court in similar situation said and set facts and circumstances in WP in criminal petition 14867 of 2024 YD order dated 5th day of December 2024 observed that the explanation and and that there is no possible explanation explaining the delay caused in lodging the FIR, which is being done after a belated stage of 14 months after conclusion of the agreement. And we would refer to so and so judgments. And for the reasons alike, since the and that the prima facie that the FIR lacks certain ingredients in view of the reason that the reason stated in the FIR emanates from the contracts entered by the government by the government wherein matter requires examination. First of all, in view of the same, this court under exercising powers under section 482 of CRPC grants the accused protects the uh, directs that the investigation may go on, and that the petitioner and the which is pending on so and so crime number pending on so and so possession is directed not to arrest the petitioner for a period of 1 week. For a period of 1 week. However, the investigation.
Would your, my lords, I only have one request. Would your lordship have this? Your lordship will say list it on that date. Your lordship will say list it on that date. Only please say interim order till then, till the next date of posting.
Hmm? 1 minute, 1 minute. Interim validate 20th. Up to 30th. Let a counter be filed by next date of hearing.
No, my lord, your lordship may post it next week. Your lordship said 1 week. Let it be 1 week and let it be there, my lord.
No, there are in two holidays like Saturday and Sunday. Let it be up to 30th. Meanwhile, you file counter. Next date of hearing is after 1 week. There shall be not any stay of arrest up to 30th. That's all.
Lordship,
detailed order would follow. 27 matter is posted. The orders are there, interim orders up to 30th.
lordship, please. I'm obliged.
1 minute. Is this matter anybody over? What are you saying? Yes, Chappan.
Lordship.
Monday. That's fine, but who is the respondent counsel? Which item is that? 30. Order in 33 and 35. There shall not be any coercive steps to be taken by the municipality for a period till Wednesday. Give a date till Wednesday.
Item number 62, my lordship.
Till Wednesday. Wait a minute. Date.
Lordship, item number 62, my lordship. Item number 62.
2060.
Item number 62, my lordship. Kindly post it next week, my lordship.
Next week. Item number
62, my lordship.
62.
96.